Hello, everybody. I'm Tom Christensen. I'm the director of the China and the World program here at Columbia University. This is our first speaker series event of the semester in spring 2025. We have a special guest here today in Professor Peter Dutton. Peter Dutton has an illustrious career in national security. He has a BA from Boston University, after which he joined the U.S. Navy as an officer. He was a naval aviation officer on the A6 Intruder for several years. He then went to law school at William & Mary and got a JD degree. And he, in addition to his uniform Navy career, he had a very long career at the Naval War College in Newport, Rhode Island, teaching the future leaders of the U.S. Navy. He has a PhD in addition, if that weren't enough, from King's College London. And he is not only one of the most generous public servants I know, he is also one of the true experts on the nexus of international law and international security. It's really hard to have someone more qualified to talk about the subjects he's going to talk about today. And his talk is entitled Power Maritime Law in East Asia. And I think I got it right.
Close enough.
Close enough. It's good enough for government work. so not a good expression. I just on a personal note, I'm thrilled he's here. I've considered him a friend for several years. And if you're out there in this Zoom land or you're in this room and you're thinking about a career in public service, I can't think of a better role model than my friend Peter Dutton. So over to you, Peter.
Wow, thank you very much. That's really nice of you, Tom. Thank you. So yeah, today we'll talk about power and law in Maritime East Asia, actually, and the nexus between them. I think, actually, yeah, I could just take this one. I'm going to stand up. Hopefully that doesn't mess up things in Zoom land.
Do you want me to control the slide?
Sure. Okay, that would be helpful. Sure. Thank you. That's really nice of you. So, Law and Politics in Maritime East Asia is the title today. And by the way, this is, so I had to bring a little Yale to Columbia. This is from the mosaic from the Yale Library. And this is alma mater, the mother of knowledge, right? So I don't know, it just kind of made a good introductory slide, I thought. So that's the bottom line, that I'm hopeful that I can help you to understand a little bit more deeply the dynamics of what's going on in East Asia and how it actually matters on a much more global basis. So let's go to the next slide. Yeah, so I'm really going to be talking about two linked things today. So the South China Sea and the maritime challenges around Taiwan. I've got two major projects working on both of those areas, but I'm going to bring them together a little bit today. We're going to see some of the sort of trend commonalities between them. And the fundamental driving question that I had, that sort of propelled my initial work was, what kind of maritime order does China in fact want? And why? Why is it so different from the order that the United States seems to want? And then maybe it isn't so different in some ways, right? So and why are there some ways it's different and some ways it's not? And how do we begin to interpret that? That propelled my dissertation. When I did it at King's College London, this was a question that I sat across the table, not much wider than this one, with Chinese on one side and Americans on the other side. And I swear somewhere in the middle of the table, there was a lack of communication hitting, even though we were using the same words. And I wanted to begin to understand why. What is it that, why is it that we are even talking about the exact same things and the exact same words, and we can't seem to connect the meaning? So I began to think about those issues. Let's go to the next slide. So we'll start with the South China Sea, and because I'm sure you're all experts in maritime law, but just in case there's someone here who's not, what I want to do is I want to point out two very fundamentally different approaches to legal order in the South China Sea. And this map it does it brilliantly. This is from the Economist, actually. It's been lifted a million times, but at least we'll give them the credit for it. So you can see the dashed blue lines. These are the coastal states, what are called exclusive economic zones. This is I'm getting a signal from the back. Are we doing all right back there?
No, she's just asking if you wanted a clicker to control it.
Oh, no, it's okay. Thanks. The exclusive economic zone is the 200-mile resource zone that coastal states are entitled to claim. And there are cases where there's overlaps. We'll talk about that later. But there are cases where there's overlaps. But a 200-mile exclusive economic zone is what every country is entitled to claim on the basis of the international law as it codified in the United Nations Convention on the Law of the Sea. By the way, that was negotiated here at the United Nations, around the world, but finalized through the United Nations in 1982. China actively participated in about 10 years of those negotiations in various ways. That's not something they emphasize because they have very different views than what are codified in the convention. But China actually did participate rather actively, recognizing that they weren't necessarily going to benefit from the outcome, but they pursued other objectives. They pursued, for instance, building a coalition among the developing states, the Group of 77 and the developing states, and they were effective in doing that. They also pursued a objective of marginalizing Taiwan, or the Republic of China, politically, and they were effective at that during that same period. In part, what they did was they made a trade-off for they supported the exclusive economic zone, which was very important, for instance, to many South American states and Central American states, in return for their ultimately switching from a support for the Republic of China to the People's Republic of China. They were during that time period in the 70s and 80s, they were very effective in doing that as this was being negotiated. So they pursued different objectives, and then after the convention came into force, they began to figure out how to integrate their interests, despite the fact that the convention didn't actually meet what they wanted to achieve. And what the Chinese wanted to achieve is this red dashed line here, often referred to as the 9 dash line or the 10 or 11 dash line, depending on how you look at it. But what you see in the blue dash line is the standard legal definition of a resource zone. In the middle here in the South China Sea, you can see this comma-shaped area. That's actually high seas, right? So area that all states have an interest in. And so you see a very different approach compared to this 9 dash line in the South China Sea. That's what China claims on the basis of, we'll talk about that more in a minute, but on the basis of really of history rather than of law. Maybe they have a legal approach as well. So there's what I refer to as the outside in and the inside out approach to defining their rights in the South China Sea. We'll end this portion by explaining what that means. So two very different approaches to governing space in the South China Sea. China claiming, I mean, this is about 1,200 miles from the mainland Chinese coast, actually. So claiming quite a bit of the water space there in contravention to the United Nations law of the sea. Let's go to the next slide. So I want to frame the discussion today around this 3 disputes and 3 objectives. So I wrote an article titled that, and that's loosely where I got this from. But I want to explain for you what the 3 disputes are, and I'll focus on the 3 objectives that relate to security that are propelling China's interests. Okay, so next slide. So sovereignty. So the first area of dispute is sovereignty. And the question is, what approach will govern who actually owns the territory in the South China Sea? So there are 4 island groups in the South China Sea. They're referred to as the 4 Sha, this is Sha, or the 4 Chundao. Chundao is archipelago, Sha is islandish. Island or island group. It's sands really is, I think, the better translation if I'm not mistaken. So they're really essentially sandbars or small coral features for the most part. And they, in Chinese, it's, forgive my pronunciation, it's not great, Dongsha, which is the province, Xisha, which encompasses, at a minimum, Scarborough Shoal, Nansha, which is the Spratly Island group in the south of the South China Sea, and then Xisha, which is the Paracels. So those are the four islands.
Zhongsha is the one you left out.
Zhongsha, yeah, Zhongsha is the middle, Scarborough Shoal. Yeah. Did I?
You said Shisha twice. That's
Oh, did I? Yeah, Zhongsha is the, thank you, is the Scarborough Shoal. See, you know all this, see? So, okay, so these are all islands and therefore territory and therefore subject to a claim of sovereignty. Sovereignty law is very different from law of the sea, completely different. And in sovereignty law, actually power and history matters. But when you have when you control the territory, when you physically control the territory, you really only are entitled to a 12-mile territorial sea. So that, let's back up one, if you don't mind. So that red dashed line there, it's really not according to the law. It's really not, you're not able to control the water space or claim the water space in the South China Sea based on those small features because they are only entitled to a 12 nautical mile territorial sea, which we know because there was an arbitration that told us about that. So, so what that would look like, even if China were able to claim all of those islands, sovereignty over all of those islands, would be some sort of Swiss cheese approach, right? Little circles around these small features, the rest of the water of which would belong to the coastal state, based on these sort of blue dashed lines. Next slide. So, sorry, we'll stay on the sovereignty for a second. So sovereignty is one of the issues in the South China Sea, and it's different from and separate from the maritime claims. We're going to see a collision course between these two things in a minute, though. Next is the maritime claims. So sovereign rights, these are the resource rights I mentioned that are based on the exclusive economic zone. So the resource rights include both the fish and the water column and whatever living resources there are, but also the seabed and sub-seabed, right? So you can see this basically shows you where the coastal states have their oil and gas concession maps drawn out. And of course, the 9-dash line runs right through here. And so every one of these coastal states is on a collision course, right, where it comes to resource rights with China. And so China has actually actively interfered with or prevented each of the coastal states from accessing some or all of its resource rights within the exclusive economic zone based on this dispute about who gets to control the waters and the resources within them in the South China Sea. China's basing its claim fundamentally on history. It hasn't really explained a lot about what that means yet. Whether China is sort of hearkening back to a pre-modern period where China was the dominant power and could dispose of territory at its will, or whether it's something else. China hasn't really clarified what it means yet by China has historic rights to the South China Sea and the water space within them. But they do include the resources as part of their historic rights claim. And so it's an exclusive economic zone-like claim within the entire 9-dash line in the South China Sea. Geography is how the law defines the resource rights in the South China Sea, but China claims them based on some form of history. We're not exactly sure what that is yet. So next slide. So that's the second area of dispute. Okay, there's one particular area in the South China Sea where the sovereignty and sovereign rights come into collision with each other. And it's really important because it's a hot issue. I mean, this is really a dangerous issue, I would say. And I'll explain why. So this is Second Thomas Shoal. The Second Thomas Shoal is a small underwater feature in the South China Sea that is, next slide, on which the Philippines grounded an old American landing amphibious craft, and they grounded it there decades ago.
1999. Yeah.
Thank you, 1999. And it has barely held together since then. But the bottom line is this is a Philippine naval vessel grounded, I would venture to guess, on purpose on the shoal. I can't say that for sure, and I don't think the Philippines says it for sure either. China claims that they did it on purpose, though. And so it's on the shoal. Now, the shoal is within the 9-dash line, so China claims this space. The question is how? How does China claim this space?
That one was perhaps.
All right, thanks. So better? Is that better? So, China claims the space. The Philippines claims it as part of their exclusive economic zone, and the seabed as part of their continental shelf, which is included in the exclusive economic zone. And that's exactly what the arbitration decision in 2016 verified, that this is an underwater feature, therefore, I say underwater feature, technically it's called a drying feature, meaning it's above water at low tide, but below water at high tide. So under international law, that means it's part of the seabed. So the Philippines claims this area is part of their seabed, and that is what the arbitration decision in 2016 verified. It's part of the seabed. And to ground or to create a structure on your own seabed is perfectly lawful. Think of, for instance, an oil platform, right? Perfectly lawful to do that. So in that sense, from the Philippine point of view, it's perfectly lawful to have a structure on your own seabed. And that's the Philippine point of view as to what's going on there. Next slide. It is not the Chinese point of view. So the Chinese point of view initially was a little bit, it lacked a little bit of clarity, but the Chinese claimed sovereignty in that area. Now, it's unclear exactly how China claims sovereignty, whether that means they claim sovereignty over the water space through one of the various approaches to claiming sovereignty over water space, or whether something else was the basis of sovereignty. I think that the Chinese have begun to clarify that they claim sovereignty on the basis of territory, because there's been a relatively new publication called the Chinese have published new Navy sailing directions, it's called. And in the sailing directions, they specify that this is actually above water at high tide. In other words, they say as a scientific matter, the arbitration decision was wrong, that this is above water at high tide and therefore susceptible to a sovereignty claim, right? So from the Chinese point of view, they're protecting sovereignty over the Second Thomas Shoal. So now we have a collision between the sovereignty law and the sovereign rights law, right? Law of the sea versus sovereignty law. But we have a couple other collisions too. So the first paradigm is that sovereignty versus sovereign rights. So let's click again. Sovereign rights or sovereignty, right? So there's a dispute over how do you consider this? And if it's sovereignty, we know that the Chinese leaders have said not 1 inch of territory will be relinquished, right? We're not going to give up 1 inch of territory. And if this is 1 inch big, something as small as this table can be claimed as sovereign territory, or even smaller, as long as it's above water as high tide and naturally formed. So the Chinese are, on one sense, protecting sovereignty, but the Philippines is protecting their sovereign rights, right? So that's the first paradigm problem. Second, what law applies? So the Chinese are applying national domestic law, right? Law enforcement. So if this is your sovereign territory, you have the right to allow access or not to others. And so the Chinese are using law enforcement, use of force, policing power. That's why you see the Coast Guard out there. And law enforcement use of force against, this is a Philippine vessel that was sent to resupply the Hulk there on Second Thomas Shoal. And it's actually a sovereign vessel. That's important here in a minute. Why? Because it's under contract to the Philippine government for a government purpose to resupply the ship. So a sovereign immune vessel, also one applying a law enforcement force against another sovereign immune vessel on a mission to resupply its armed forces in a space that it believes it is lawfully, where they lawfully reside. So next, okay. So here you have a third paradigm problem, right? Which is law enforcement versus national self-defense. So ironically, even though the Chinese claim sovereignty over the feature, and they're employing law enforcement, right? Limited use of force to achieve a law enforcement objective. But on the other end, this vessel is a naval vessel, a sovereign immune vessel on a naval mission. It has a right to use force in self-defense, right? National self-defense applied to a unit is unit self-defense. So they have a right to use force in response. They could escalate if they chose and used physical force to defend themselves and their mission from the law enforcement use of force that the Chinese are applying against this vessel. Now, they haven't. I think one more. Yeah. So in a sense, both sides are exercising a certain amount of restraint, right? So the Chinese are applying, rather than using armed force, they're using non-lethal means of force. I say non-lethal because they have at least caused injury and they could cause real harm by the kinds of forces that they're using, but it's not bullets and bombs. So non-lethal use of force in a law enforcement approach. And the Philippines are not responding by using armed force in response, although international law would allow them to do so, right? So you have a lot of two fundamentally different paradigms in conflict here. And both they're susceptible to misperception with the result of unintended escalation of real possibility. And that's important to the United States because we have a treaty with the Philippines to defend not only the Philippine main island territory, but also their naval vessels. So it could potentially implicate the United States. And so this is a very dangerous situation where there's a collision between different legal approaches, but really what's underneath it all is a power dynamic. Fundamentally, it's a power dynamic. The law is, in a sense, framing how each side is pursuing their interests, but underneath it all is a power dynamic. Next slide. Okay, so the third dispute in the area has to do with the coastal state versus the user states, and what are the balance of rights and obligations. China, as a major continental power, has pretty consistently looked at especially its regional waters as an area in which something called mare clausum, right? This is Latin for essentially jurisdictionalization, enclosed waters. Jurisdictionalization of waters and the authority of the coastal state to limit foreign military activities off its coasts. Now, up to 12 nautical miles from your coastline, that's your territorial sea. And you have, and the airspace above it is national airspace. You have a sovereign right to prevent any kind of military activities in that space. But beyond that, that's not how UNCLOS works. UNCLOS says that user states have a right to exercise military operations and military activities in that airspace. So that's the basis of the dispute, not just the United States. In fact, I think this might have been an Australian aircraft here, but Chinese intercepts of Australian and American, certainly American aircraft in that region is quite common. So there's a dispute over what the balance of rights and interests are between the coastal state and the user states, with China wanting to exercise more jurisdictional control, particularly over security activities, the United States and some others emphasizing mare liberum, freedom of the seas, right? This is a 500-year-old debate. We can talk about that in Q&A if you're interested, but it's a 500-year-old debate that goes back to the time of Grotius and Selden and the Dutch and the Portuguese and the British and everybody trying to figure out, how to engage in trade around the world. So these are the three different disputes, right? Sovereignty, sovereign rights, and what's the balance of rights and obligations in the coastal waters. Next slide. So I, until recently, was on the faculty at NYU Law School, and I taught a course there and also did research. I had a research project funded by a Japanese grant, actually, that we looked into maritime dispute resolution And we looked at what we could learn about maritime dispute resolution by looking at quite a few different cases. We wrote case studies that are on file there. And I wrote about a 50-page report, I think, that summarizes the law regarding maritime dispute resolution and then make some recommendations about how we could more productively move forward. But the bottom line is you have to be interested in maritime dispute resolution on some basis of a common ground. And so far, we're really struggling to find what that common ground is between the coastal states in Southeast Asia and China. So it was a great project, and I hope that it has continued utility, at least if nothing else, as a resource for people to go to understand what the tools are available. I've also done some writing on this. There's a whole range of really good approaches to sharing water space and the resources in them that are used on a global basis around the world. There are all kinds of different approaches to resolving these types of disputes. And I'm happy to talk about those in Q&A if that's of interest. Next slide. So remember I said there's an outside in and an inside out. So the 9-dash line, if that's the outside in other words, based on this 9-dash line that was bequeathed to the PRC by the ROC, by the way, that 9-dash line is the outside in approach, sort of history as, some basis for claiming the water rights within there. And frankly, all of the islands within that as well. There's an outside in approach, and that's the outside in. Sorry, there's an inside out approach. And the inside out approach is based on something called baselines, where in the law of the sea, baselines are the starting point for each of the different jurisdictions, territorial sea and exclusive economic zone, et cetera. China has done something that the law does not support, which is just, it collectivizes the islands with baselines. Rather than around the low water mark, which is the normal approach to baselines, there's no law that says you can draw baselines around these groups of islands in the South China Sea. We know what they look like in the parasols because China has published them. This is just a notional approach. It's not, this is something actually my colleague Isaac Carden drew up for me one time. And it's just a notional approach of what the two groups of islands in the South, the Spratly chain might look like with a 200-mile exclusive economic zone drawn around them. The Chinese in conversation have actually used this approach, both in their public discussions, but also in conversation, have used this what I call inside-out approach, right? So it does not comply with the law, but it uses the language of the law. So it's a really interesting development. And I'll explain a little bit what I mean about that in a second. It's an interesting development that they're now trying to use the language of the law. This is post-arbitration, by the way. Trying to use the language of the law to explain how China has jurisdictional rights to the South China Sea, even though their approach does not actually comply with the law. So next. Yeah, so there's a couple of paradoxes, right, that this brings up. One is, does China actually mean for its approach in the South China Sea to become law, right? So is China seeking to be exceptional? Or is China seeking to change the law? We hear from Chinese leaders that they want to improve international law or make changes to accommodate China's interests in international law. Maybe this is one of them. Or is China seeking to be exceptional to the basic rules of international law? We're not sure yet. And if you look at the 9-dash line in the historic right, that's an approach that is, well, it just doesn't comply with the law at all, and so it would seem to be an exceptional approach. But here, when we're using the language of the law, it could be at least construed as a evolution, a development in the law, sort of moving it beyond what the convention actually is and how it's been interpreted to some sort of new approach that uses the existing law but applies it in a new way, right? So you could, I don't know where China stands or where exactly it's headed on that issue. Next one is, why does China upset its neighbors? So, I mean, this is a real paradox, right? So because the Chinese have long said they want the United States to stop meddling in the South China Sea, stop forcing countries to choose between China and the United States. And, you know, they criticize American presence there on a very routine basis. But why is there such an open door for American presence? It's because the countries recognize that their rights or their legal rights, their interests are being infringed upon by China's approach. And China's using its power to enforce its limitations on what its other coastal neighbors can do. So why does China continue to upset its neighbors when, in fact, if it were more conciliatory, it would benefit by having much improved relations with its neighbors, but it would also make American power in the region less necessary, less useful to other coastal states. So it's a little bit of a paradox. I'm not sure how to answer that yet either. Next slide. All right, so now let's talk a little bit about the why part. So click 3 times, I think. Yep, so remember I said I would focus on security. So national security, China's had 2 centuries, really 2 centuries, since the end of the 1790s, really. Since the 1790s, China has had various revolutions, uprisings, wars, foreign wars, and has really had, hasn't all been chaos, but a lot of it has been chaos in China. And so national security is something that the Chinese are thinking about as they're thinking about how to manage their periphery. Regional security, right? They've also had 2 centuries of external dominance, at least 2 centuries of external dominance on the maritime periphery. You can even go back to as early as the mid-1500s with the Spanish and Dutch trade going on in the region, and the Europeans and Portuguese just very active in the region with superior naval power, frankly. Beginning as early as that period of time. Now, it didn't really result in wars with China until the 1800s, but 2 centuries of external dominance at a minimum on China's maritime periphery is another reason why China's thinking about controlling its periphery. Finally, party security. This is something we can talk about later if you like, but demonstrating efficacy is really important for what the party can do, and especially as economic benefits are less apparent right now, being able to demonstrate efficacy as part of, as supporting China's national interests and its claim to territory, especially irredentist territory, is an important reason for pushing on the maritime periphery as well. Next slide. So national security, this is how you might think about this. These are just missile envelopes, but the visual is really good.
Just missile envelopes.
Well, yes, I mean, this is very important in that sense, but the visual, what I'm trying to show you is the visual of like how a continental state thinks about the maritime periphery. If you think about archery bullseye, where the center is the high value, right? And then you have decreasing rings of control around it. That's what China's trying to create, not just with missiles, but with law, with jurisdictional approaches to that balance of rights and obligations that I mentioned earlier. So decreasing control the farther away you get, but increasing control the closer you get. Makes sense as a sort of management to national security. Management approach. Next slide. Okay, regional security. So China, we talked about this a little bit earlier, is maintaining stability through expansion without escalation. That's the objective that China is trying to pursue. Expansion into the maritime domain without escalation, particularly in the South China Sea. I'm not so sure yet about Taiwan, we'll see. But also, I think one of the things that China is really trying to do is improve its status within the regional order by attempting to set the rules. It's not just setting boundaries, it's setting rules about how the region will work. And so that's a status issue, building China's status in the region by setting the rules about how claims can be made and how disputes, in particular, about how disputes will be resolved. Next slide. All right, party security. So the China Dream and
That was the maritime militia, right, in the picture?
that was the maritime militia.
Yeah, I want to say something about them, because I don't know if they know what that is.
Oh, I beg your pardon. Okay, so so there are three maritime forces that China maintains. All of them fall under the People's Armed Forces. One is the Navy, right? So it's the military PLA. The other is the Coast Guard, which falls under the police, and then the Third is the Maritime Militia, which falls under the militia. So all three of the People's Armed Forces are active in the pursuing maritime domination in the South China Sea. And so this is a picture of the militia. The militia is of two types. These are private fishing vessels that are incentivized to support China's mission, even paid in various ways to support China's mission, trained as a militia to support China's maritime expansion missions. And they sometimes quite literally flood the zone and crowd out any of the other fishing vessels, or exercise a sort of control over a feature that China wants to dominate. That's how the whole dispute over Scarborough Shoal started, actually. And there's a second militia, which is actually purpose-built, very reinforced fishing vessels that look like fishing vessels but are not. They have the water cannons. They don't have any fishing nets or any fishing gear, but they look like fishing vessels, and they're reinforced to do things like ramming it, et cetera. So yeah, it's a pretty rough bunch out there exercising control in areas where China's trying to outmuscle its neighbors, frankly, with sheer numbers.
Sorry to
Oh, that's okay. The next, so we talked about the China dream and demonstrating efficacy. Well, we could talk about what this is all about, but this is one of the three big bases in the South China Sea that China built out of literally a tiny little feature, right? So each one of these is huge, bigger than the combined Hickam Air Force Base and Pearl Harbor complex in Honolulu. They're huge, and there are three of them in the South China Sea. I personally don't think that the United States was the objective in why they built these. The United States is quite active in the South China Sea, and China can't stop that short of actual armed conflict. And even in armed conflict, they would have to fight us for it, right? So I don't think that's what this is about. I think this is about demonstrating power in relationship to their neighbors, where this really matters, right? If you're the Philippines or Vietnam or Malaysia, it really matters that China has the capacity to project so much power in the region to control what they claim. But also it's demonstrating efficacy to the people of China, that you have power and you're exercising your power to claim what you claim, to control what you claim. Okay, next slide. So let's talk for just a short couple of minutes about Taiwan. I have a whole separate project on Taiwan.
It's not controversial. Man.
No, it's not. It's no big deal, really. I mean, it never has been, right? So we'll talk about a little bit about Taiwan. I could do a whole course actually on international law in Taiwan. I wouldn't try to do the politics, but the international law in Taiwan, it's a fascinating issue. I'd be happy to talk to anyone about it. I've got some publications coming out over the coming months on this, relating international law to the situation in Taiwan. And I just want to briefly introduce that. So next slide. So China's position is quite concise and clear, right? It's called the One China Principle. Back up.
Sorry, I thought
That's
I
okay.
moved it.
Nope. Sorry. So unambiguous, it's called the One China Principle, right? It's got three parts. There's one China. Taiwan is an inalienable part of China, and the People's Republic of China is the sole government representing all of China, right? So clear, concise, no questions. How did you get there? Sort of as a lawyer, looking at this question as a lawyer, how did you get there? It's a very difficult thing to answer, other than just simply stating it as truth and expecting it to be thus, right? So next slide. I'm condensing a whole lot of history here, but this is actually a photograph of the handover in October of 1945 from the Japanese on the right to the Chinese general on the left of control of the armed forces it's a surrender actually of Taiwan to the Chinese. So there's a debate about this. The Chinese say, see, they surrendered to us, it's now our territory. That completed a series of agreements that were made between the Allied powers, and we are therefore now the sovereign of this territory. The other narrative is the Chinese received occupation the same way that the Russians and the Americans received occupation of other parts of Japanese territory at that point in time. Why? Because territory, as a matter of law, has to transfer through an instrument of transfer, typically a peace agreement. Even where conquest has been historically the approach to taking territory, it is finalized as a matter of law through a treaty of peace between the two countries. And there's a really high premium in international law on this issue that affects a lot of different elements of of how Taiwan moved through time, because this very high premium on clarity of sovereignty over territory is just fundamental to international law, because it's so fundamental to how peace and war are conducted in international relations. Sovereignty over territory, therefore, as a premium in international law, has to be clearly addressed as a matter of treaty. So, next slide. Which gave room for President Truman, June 27th, if I remember correctly, 1950, to say, we're not going to complete our political agreement to turn over sovereignty of the territory of Formosa, Taiwan, and the Pescadores, which were part and parcel of it. They had been Japanese territory since the Treaty of Shimonoseki in 1895, because that territory was ceded to Japan by treaty by the Chinese at that time. So,
Other way around. Ceded to Japan by China.
thank you for that. Yeah, ceded to Japan by the Chinese at that time. So they were Japanese territory. From 1895 to 1945, at a minimum, there's no question of whose territory that was. As a matter of international law, it was still Japanese territory until the peace agreement was signed. So that peace agreement was signed also, 1951. Again, I'm trying to get my dates. 51?
Yes, but no.
Okay.
So San Francisco was 1951.
Yeah.
But the U.S. interpretation on June 27, 1950 was a peace settlement that involved all the major combatants in World War II, and
Okay.
Japan and Russia. Japan and the Soviet Union, or the successor state Russia, has yet to sign a peace treaty.
So
So Taiwan is still in limbo.
that's exactly it. So I did not realize that little detail of it, but that's an important one. But our policy is that this remains the state of play.
Undetermined.
The sovereignty over Taiwan and the Penghu Islands is undetermined. This is important. This is important for lots of reasons, but one reason is, and this is a whole project that I'm working on publishing, is that as a matter of international law, that changes the nature of what another state could do in the case of a conflict. So as I think about the status of the territory governed from Taipei, there are actually three types of territory. There's Taiwan and the Penghus, which the status of which sovereignty over which remains undetermined. There's the Jinmen and Matsu and the small islands pertinent to them, which in my view are clearly Chinese. There's no other claimant than China. The only question is the government over them. That's a different question than sovereignty. It's a question of which government has the authority over them. Then the third type of territory is the territory that Taiwan controls in the Spratlys, which is Taipingdao or Ituaba. That's disputed by multiple states, right? So you have three different types of territory controlled from Taipei, in my view. And each one has a different status. So if I were asked to advise the president about whether armed force should be used to defend an attack by the mainland against Jinmen and Matsu, I would say no. As a matter of international law, that's Chinese territory. And this is a dispute between governments. It's an internal matter, would be my answer. If I were asked about whether we have the international law authority to help defend Taiwan, if Taiwan is attacked, and by that I mean Taiwan and the Pescadores, the answer I would say is you have that authority. If you want to exercise defense, collective self-defense, you can. Why? Because the government in Taipei exercises authority over territory that is not Chinese yet. Perhaps technically, maybe never will be, but it is different from Jinmen and Matsu because the sovereign status of that territory remains undetermined. So these things matter a lot if we're thinking about a national policy of supporting Taiwan militarily should there be conflict. And the same thing in the South China Sea.
Could you say one thing about this?
Yeah.
That in the original treaty between the United States and the ROC on Taiwan
Yeah.
in 1954-55, Quemoy and Matsu, Jinmen and Matsu were not included in the areas under the treaty unless the takeover of those put at risk, and Chiang Kai-shek hated that because he claimed Quemoy and Matsu and the rest of China,
Yeah.
and the United States said that's not what we're about. We're about this undetermined territory, and only if that undetermined territory comes under.
And as a lawyer, I came to that from not the political angle, but the legal angle, and I understand why that can be. I also understand why the fact that there's different types of territory gives the governments, the successive governments on Taiwan, the capacity to use that to their advantage when they're trying to describe their status, right? Are we separate? Yes. Are we the same? Are we part of China? Yes. Well, how? The international law issues help you at least to have one answer to that question or to those questions. So next slide. Just to complete this thought, Japan renounced right and title to Formosa and the Pescadores in the San Francisco Peace Treaty, which was then subsequently accepted in the Treaty of Taipei with the Republic of China. And yet, so renunciation of the territory is not the same as assignment of the territory. That is the critical final step that has not been completed as a matter of international law on the status of Taiwan.
So they're just saying it's not ours.
That's right. They're just saying it's not ours. Yeah, exactly. We're walking away from this property. Yeah. Back away slowly. So next slide. So this brings me now, as a lawyer, I'm coming back to thinking about this question in a way that I think is different from some others. So next, click. Okay. So we know that the sovereign status of Taiwan is undetermined, right? At least if you buy my approach, which I think is consistent with at least what the American government thinks. Mm-hmm. Next. Click again. But China's political activities may change that. This is a really important and interesting evolution from the position of a lawyer. Next, one more. And they may change the way international law works, because the law of sovereignty has, as we talked about already, has finality and certainty, and the process of transfer in terms of through a treaty, the vehicle of a treaty, has been the bedrock of international law related to sovereignty law, just for history. But here you may, in fact, because of the United Nations system and the distinction between, lawyers will understand this, declarative sovereignty and constitutive sovereignty. Declarative sovereignty is I am a government, I have a population, I have territory, and the capacity to engage in international relations. That's declarative sovereignty. Essentially you are able to, if you have those attributes, you're able to declare yourself a sovereign, and the expectation then is that other sovereigns will accept you among their rank. Well, there's a fifth, constitutive sovereignty has a fifth element, which is this actual acceptance, right? So it's called recognition. The fifth element, constitutive sovereignty has the same four elements as declarative sovereignty, but with a fifth element, which is this international recognition. And so through the UN process, China has been very actively engaged for decades, right? We talked about this as one of their objectives in the Law of the Sea Convention negotiations in the 70s, right? Of marginalizing Taiwan status and then getting other countries to accept the one China principle explicitly as a matter of state policy. And to the degree to which that occurs, then what could end up occurring is that despite the way international law works, and despite the American approach to the status of Taiwan, if enough countries begin to accept that the status of the territory of Taiwan and the Pungus is in fact Chinese, you may have a political solution with legal effect. And that would be, in my view, the first time you actually have that occurring, and it's enabled by the UN system, actually. First, the UN system gives a primacy to constitutive sovereignty. This element of recognition becomes essential because it's your ticket for entry into the UN system. First, recognition by the Security Council and the 5 potential veto powers, but then recognition by the General Assembly. So recognition now, because of the UN system, has become central to your status in the international system. Declarative states alone, and there are a number of them, it's insufficient to be a declarative state to be recognized as a sovereign, because you can't take advantage of the full array of international rights unless you can take advantage of them through the UN and the treaty obligation, for instance, for collective self-defense. So this is why the two questions are related. What is the status of Taiwan and what collective self-defense rights might it have are related both through the approach, the construct of the UN system, but also separately with the construct of international law. So I think that's about it. Okay, yeah, there is one more point I did want to make. So you can click 2 more times. So we see a lot of news about the military activities around Taiwan. And I don't want to minimize the importance of that. It is important. The Chinese, the PLA is learning how to improve their ability to conduct joint operations, how to manage this kind of a complex operation should they ever decide to use force. So I don't want to minimize it, but I also don't want to maximize it, because in my view, I don't believe the PRC wants to use force. That's number one. Number two, I think there's a lot of restraining factors to using force. One of them would be, we don't know, we the PRC, we don't know what other countries might do and what the cost to us might actually be. So it's not just about concern about their own military capabilities, but also what might be the fallout of using force and what other countries might do, both in the military sphere, the diplomatic, and the economic sphere. What might be the cost of actually using force? So I think these are restraining factors. But what worries me the most is that bottom picture, the Coast Guard. That worries me quite a bit, because when I saw recently that the Chinese were now doing Coast Guard operations in the exclusive economic zone of Taiwan to the east of Taiwan, right, to the east of Taiwan, and they were undertaking exercises that mimicked doing things like customs boardings of other vessels. In other words, doing what the coastal sovereign has the right to do in those waters. That was a red flag to me, because that is a potential wedge that China could drive between Taiwan and the international system. Meaning, if China begins to exercise mainland customs procedures for access to the Taiwan market, now you've number one, you have flushed out those countries that have accepted the one China principle, and they have to accept it, right? Because they've accepted the one China principle. And the countries that don't accept the one China principle now, China has economic leverage. Either you don't get to access the Taiwan market, maybe even you don't get to access the mainland market because you're not complying with Chinese PRC customs laws, right? So it's a real potential leverage that the Chinese could employ. And I mean, I'm no tea leaf reader, but that looked like a big signal to me. And not just to Taiwan, but to the international community about what could come next. So power and law together. Next slide, I think that's it. Yep.
Thanks so much. I'm so glad you're here.
Thank you.
And I'm going to ask you a question first. Well, it's a comment that you can correct if I'm wrong.
Okay.
And then a question about the UN process. So the comment is that the straight baseline approach that you said was outside of international law is not, my impression is it's not outside of international law for any state. It's outside of international law for continental states.
Yeah, that's right.
So China's clearly a continental state, so it can't behave like the Philippines or like Japan, like an archipelagic state. It is a continental state.
Japan, by the way, doesn't.
Doesn't.
The Philippines and Indonesia have declared archipelagic status.
And
Japan has not.
Okay, so it's a violation of the law fairly clearly given China's status.
That's right.
Not just an interpretation, it's a violation.
That's right.
And then for the UN, this has always been a puzzle to me.
So what I tried to be kind to the Chinese about was a reinterpretation, right?
Yeah.
This is perfecting international law.
It's very polite.
Yeah. Yeah.
So the UN process is unclear to me in that China's been trying to get a statement out of the UN that Taiwan is part of China for quite a long time. And when I was in the government, they got, I don't know how they did it, but they very briefly got the Secretary General's office to say that UN General Assembly 2758 in September of 1971 made it clear that the UN position is Taiwan is part of China. And what that document is, UN General Assembly 2758, is a document that transferred the China seat in the UN Charter. It's a seat for China, not for the Republic of China or the People's Republic of China, in the UN Charter, from the Republic of China to the People's Republic of China. And it was very short, and it had all this nasty language about Chiang Kai-shek's criminal government, right? But it didn't say anything about Taiwan's sovereign status in relation to the mainland. It just didn't. It didn't talk about it.
Well, so first of all, there's a great piece by Bonnie Glaser and Jacques Delisle on this. But really, in sort of simplest terms, it was 2758 was about transfer of government, not about transfer of territory.
Right.
There's nothing that mentions transfer.
So it's just not in there. It's not a question of like, it says the opposite. It just doesn't say anything about it.
Yeah.
And so we pushed back. I was in the government at the time. We pushed back very hard on the UN and on China for messing with the UN. And it seems like there's a very good article out in the last couple of weeks that cites Jia Ian Chang, who you probably know, at National University of Singapore, who's been studying China's efforts to get more and more countries to accept the One China principle. So my question at the end of all this is how does the UN process work on this? Because until recently, 3 members of the UN Security Council had the US version of a One China policy. France has subsequently changed, but the United States and the UK, both members of the UN Security Council, do not recognize Taiwan as part of China. They don't recognize Taiwan independence, and they don't recognize Taiwan as part of China. They have that undetermined view, right? So it can't be a UN Security Council issue. Is it a General Assembly issue? And if China convinces enough countries,
No, it is a Security Council.
so then the US and Britain will consistently block this.
Well, okay, so I guess it's the opposite way around. What I should say is for Taiwan to become a constitutive state.
Yes, through the UN.
Through the UN, it's a 3-step process. So the first step is they have to apply to the Secretary General.
Oh, Taiwan to be a state.
Yeah.
So,
I realize, but let me back into it. Okay. So for Taiwan to be a state, there's a 3-step process. You have to put an application to the Secretary General, who is then required to refer it to the Security Council. Yeah. The Security Council then has a timeline for a vote on it. And of course, it has to be a majority of the members, but it also has to be all of the a concurrence of all of the 5 permanent members, right? So this is the quote veto of a permanent member. So obviously China would veto that. But let's say this just happened recently with Palestine, and the U.S. vetoed it, right, in the Security Council. So, but if it were to get past the Security Council, it then goes to the General Assembly for a vote, where a majority of the
then
states,
it would matter.
Yeah, then it would matter. And so, and this is where that question of constitutive status matters. But what I'm trying to think through is the relationship of this process to the actual finalization of the territory of Taiwan. Now, the United States would have to veto in the Security Council any determination, any final
that Taiwan
determination
was part of
that Taiwan is a part of. Part of
so it doesn't matter. That it matters in a political sense that China has rallied now, I think 70 countries to state that Taiwan is part of China, and they go further now, and now those countries are saying, and China can do whatever it wants to unify.
Yeah,
which includes military force. But that's not a legal matter at the UN, no matter how many General Assembly countries line up, as long as 2 members of the UN Security Council don't agree.
That's right. It's a political matter, fundamentally a global political matter, because what are the pressures that could be put on that states that might want to come to Taiwan's aid, but won't because they have come to terms with China and accepted the one China principle, right? So,
Yeah, let's let other people
Yeah.
ask, but thank you.
sure. Does somebody want to look at whether there's questions online? Okay.
She's got it. Amelia should
Oh,
ask the
thanks.
she's
Yeah,
writing her
you've been doing the
she's
hard work.
writing her thesis on this too.
Oh.
Yeah,
Her
so
master's
it was
thesis.
a good recap. So I just had a question regarding obviously more recently as China increases its gray zone tactics in terms of the maritime militia and flights over the East China Sea by establishing an aerial defense zone. Do you think with the increasing possibilities of misconceptions or possible ship-on-ship contact or in air contact, do you think China's gonna in the future rely more on this kind of Coast Guard administrative Blue Sea initiative, or do you think they're gonna use more cyber or UAV type
golly.
needs?
Probably all of the above, actually. We might need to pass around a microphone, I'm not sure, for questions. But, so the question had to do with gray zone and what to expect with China in the future, whether that would be more of the sort of, blue hold and white hold activities, or cyber, or aerial, whatnot, or UAVs, et cetera. So, yeah, I think all of the above, to be entirely honest. I would anticipate, this is just me thinking it through, I would anticipate that China would want to use more of this sort of pressure because it's relatively cost-free, as China has seen, right? It has been able to use gray zone. We should probably define what that is, but gray zone activities in the South China Sea with almost no cost, but with great results, right? They control Scarborough Shoal now. They built up these islands. They now have a large militia, including a professional militia that is, kind of exercising its muscle in the South China Sea. They've been able to block other states from accessing hydrocarbons and, even enforcing some of the fishing bans, right? So this is right. So within the 9-dash line. Right, so this has been a very effective approach for China, and I would expect you would see more of that rather than military activities, at least as sort of the first strategy to achieving their aims. So what is gray zone? Gray zone is, some people say it's really just hybrid warfare. I think it's different because hybrid warfare, like gunboat diplomacy, is fundamentally about use of military force in combination with other activities to achieve a particular objective. But hybrid warfare is about use of military power as one of the elements of your strategy. Gray zone, in my view, is different in that the military is just if it's involved in any way at all, it's in the background as an escalation management tool and nothing more. Right? So it purposely avoids actually using military force to achieve its objectives. And so you're looking at lower level uses of force, like we saw with Second Thomas Shoal in that example, right? That's a classic example of gray zone strategies. So, but China's been very successful with them, and I think we're beginning to see more and more of those around Taiwan now, right? So a tried and true method in the South China Sea, I think, is being exported to other places, particularly now to Taiwan, coming to a theater near you in the East China Sea, I would imagine, before too much longer.
It's one of the greatest frustrations to me as a professor that gray zone activities are below the military levels, Coast Guard and Maritime Militia in this case, but gray hulls are the military. So gray zone is not gray hull, and I'm just like, I wish they could come up with something besides gray zone.
It is what it is. Oh,
Because it's confusing. when
I
you're
didn't come up
lecturing.
with a name, so.
Yeah, it's not your fault, I know.
But I did a piece, I published it in a chapter in an edited volume, which means nobody will ever read it.
Exactly.
But I did a piece analyzing those three things. What's the literature on gunboat diplomacy, literature on hybrid warfare, and then what is this gray zone thing? At least as to what China's doing, there is a distinct strategy from hybrid warfare and gunboat diplomacy.
Others?
Sure.
Here, I have a. Oh, it's on, so I think it works for two of us.
So apologies for being greedy with 3 questions here, if you'll indulge me, but I find this so fascinating and really looking forward to getting your expertise. I'm just wondering, first of all, what do you think explains the difference between China and Russia's approach? Both have these historical territorial claims, and you see Russia invading Ukraine. And for China, based on your really extensive reading of so many documents, I'm just wondering, why do we see this inside-out approach occurring, as you put it? Why is China really trying to work within the law in some ways, and move forward somewhat within the United Nations system, somewhat without, outside? So I'm curious about that, because China has originally done the claim as well. Second, how would you?
Oh no, that sounded like 2 to me. Can
Do you want to go first?
I will come back.
Okay,
I promise,
yeah.
but,
Yeah, then I
you're
can
gonna
pass it
see
around.
him in a little while, too.
I'll pass it around. I'll be fair.
So okay, the first one, difference between China and Russia. I think first is Russia has blown through the prohibition on aggression, just plain and simple.
Yeah.
Like, prior to what, 2022, I guess it was, when they invaded Ukraine, we were all really trying not to see Russia as actually violating the prohibition, the UN Charter's prohibition against aggression. And this, which is, if anything, the most fundamental tenet of the post-World War II order, right? Russia has just blown right past it. And China is clearly not willing to do that, and I think for good reason. China, and this gets to your second question, and the China is really concerned about legitimacy. It's about what is legitimacy? Legitimacy is a subjective, it's not objective, it's subjective view that someone else's actions are accord with what is right, right? So that's legitimacy. Subjective view that someone else's actions accord with what is right. And China actually cares that other states perceive its actions as being in accordance with what is right. And clearly Russia does not. I mean, that's a really big difference. But it also affects this question of how China behaves in the South China Sea, and why China would, once it lost the arbitration, badly, and I have comments on that too. Like it could have done much better for itself if it had just even shown up through the jurisdictional route, right? So it could have done a lot better for itself, even if it lost. But even so, China cares that it is perceived to be legitimate. Certainly at home, right? The Communist Party has to be perceived as both legitimate and efficacious, right? And so it cares as a domestic matter, but it also cares on an international basis. It doesn't want to make it too easy for other countries to sort of other China as being an outsider in the international system. And so I think, and why? Because China participates actively and benefits from many aspects of the international system, right? And wants to protect its relationship within it, its reputation within it. So I think those are important to understand for why China is different from Russia, and also why it chose to articulate a second way of articulating its rights in the South China Sea, even though it has not clarified it yet. That picture I showed you is just notional, but it has been very clear that that's what it will do. We don't know exactly what it'll look like, but that's what it will do when it articulates baselines in the South China Sea.
There's one area where the Russians and the Chinese act similarly, and that is the Russian position on the Arctic is very close to the Chinese position on the South China Sea. Without any really strong legal argument, they say this area is special and our control of it is special. And strangely, both the United States and China disagree with the Russian position in the Arctic, even though China has a similar position in the South China Sea, because China wants to have free access to the Arctic, just like the United States does.
Yeah, the United States is no, knight in shining armor here, in the sense that although we are consistent, we promote freedom of navigation on a global basis, full stop. But we refuse to put American, the American interests at stake by becoming a member of the United Nations Convention on the Law of the Sea.
It's not been ratified.
Yeah, we've never ratified it, and I think honestly, now it's too late. It doesn't even matter anymore, because the system has just blown right past that.
Thank you.
Thank you for a really interesting talk. Two questions. The first is you mentioned like,
Stick with one first.
okay, okay, so I'll go straight to the policy question then.
All right.
So, as you mentioned, China has a white hull, has a Coast Guard advantage in the South China Sea.
Huge.
A huge hook, yeah. From a legal perspective, does it matter if the U.S. responds with gray hull, like in a hypothetical incident? Does it matter if the U.S. responds with a naval vessel or a U.S. Coast Guard vessel, which also operates in the theater?
Yeah, I think it does. So the way I conceive of it is there's two asymmetries that China's taking advantage of. You've touched on them both. The first is the asymmetry of size, right? So they can use their Coast Guard. They have 10,000 ton cutters, which this is the size of a destroyer. A reasonable sized destroyer. These are huge vessels, right? They have and not just one of them, right? They've got a bunch of them, and they have but they have the largest Coast Guard in the world by far as well. So each of their neighbors has a very small Coast Guard, frankly, both in terms of tonnage and in terms of numbers. And the U.S., frankly, we don't have a reason to be there. It's not our exclusive economic zone. I am of the view that we should not be sending the Coast Guard to the South China Sea. There's a big policy debate about that. I come on the side of don't do it. We have other interests. We should be using them to help small Pacific states police their exclusive economic zones. But, and so the United States has no particular reason to get directly involved in a law enforcement effort that it belongs to the other coastal states. So China's taking advantage of this asymmetry of size vis-a-vis its neighbors. Then there's an asymmetry of type, right? Which is okay, the one other big kid on the block is the United States Navy, which could get involved. But now you have an escalation management issue, right? So the Chinese have actually lightly armed, and in some cases have not armed their Coast Guard vessels, I think on purpose, right? To take away this potential escalatory issue, and to try to keep the Americans out of it by using law enforcement, non-lethal means to deal with the problem. So would it matter? Yes, because you have a naval vessel that has lethal use of force capabilities against a Coast Guard that's a Coast Guard vessel that does not have that capability. That's inherently escalatory. And I think the Chinese are taking advantage of that, knowing that we don't want to escalate either in the South China Sea. So they're taking, these two asymmetries they're taking advantage of. Did that answer it? Yeah. Okay. I think there's a hand over here too.
Oh, yes. Jennifer?
I had a very similar question.
Oh.
You just answered it between the asymmetric naval forces against Coast Guard forces.
Okay, sure.
Hi, this was really interesting. I'm wondering, you said when you were talking about the South China Sea, or unless I'm misinterpreting you, that you see these actions, these Chinese actions, they're not primarily directed towards the United States. You think that countries like the Philippines are the primary audience, because if you wanted to get the 7th Fleet out of the Pacific, you'd have to fight us. And I wonder, while that is true, when you get to that question of motivation that you pose about, why piss off your neighbors, why try to upend this order, whether at that larger zoomed out picture, it might have something to do with when the Chinese look off of their southern coast, right? They see a maritime order that looks something like encirclement by American friends and allies. And I guess a follow-up question would be, could you imagine a more deft pattern of Chinese activity in the South China Sea that could, to some extent, undermine the American security position in the Asia Pacific?
Yeah, thanks for the question. This gets to the dispute resolution issue. So if I were advising Xi Jinping, how do you, so because there's a contradiction, right, between pursuing your national security interests in a maximal way, right, and pursuing your regional interests. And sort of exercising leadership among your partners and marginalizing American power. How do you overcome that contradiction. And I think it's very simple. Somebody asked me this a long time ago. It was at an evening thing at Harvard. Somebody in the back said, "So what's China supposed to do?" My answer was 2 words: be nice, right? So it's the bottom line is, if China were to engage in one of the approaches that have been used around the world in the South China Sea, to actually recognize, number one, that those islands have never been controlled by any state until actually midway through the 20th century, really. They have never really been controlled in the territorial sovereignty sense, right? And recognize that this is a fluid region where all of the coastal states in particular had interests and activities for millennia in the South China Sea, and develop some kind of open order among the regional states in the South China Sea, perhaps even policed and patrolled by China, but where each of the regional states could access oil rights off their coast, could share in the fishery resources in the South China Sea. A good example of this, for instance, is the Northwest Atlantic Fisheries Organization. It's a high seas fisheries organization, right? Nobody is sovereign, or no sovereign rights over this, but there's a lot of interest in managing the fish stocks of the high seas. And so all of the countries of the North Atlantic came together and not only agreed on a total allowable catch, an allocation of that total allowable catch among the states, but then also mutual policing, right? So you could do something very similar to that in the South China Sea under Chinese leadership. And I think the coastal states would be very interested, and would have an interest in, reducing ties with the United States, security ties, because China's less threatening to their interests. So you could do something along those lines to both satisfy the regional states, improve your status position within the regional order, and marginalize the American interests in the region, all at the same time.
So just on a personal note, I have a brother who had that job in the Northwest.
Oh, did you really?
Yeah, he used to ride around in Japanese fishing boats.
No kidding.
Speaking no Japanese. And all he was there for was to observe their catch, to make sure they weren't, usually to make sure they weren't catching fish that were too small, because they would have to grow up. So the small fish had to be returned to the ocean.
Yeah.
So that was his job. It was an unusual job.
I'm a New Englander. I'm very familiar with the coastal fisheries. So yeah, that's really cool. Hi.
I have a question from the Zoom audience.
Okay.
So this one is from Nax
I know
Hamush.
Nax.
Okay, great.
Yeah.
So he asks,
Yep.
what, in your opinion, is the Trump administration's attitude towards the territorial disputes in the South China Sea?
Boy.
Do you see a change in U.S. foreign policy? Do you
always ask the tough
expect a more hawkish attitude?
He's a really smart guy who did really well in my class at NYU. So I don't know that the Trump administration has formed a policy on these issues yet. I haven't. So new people in the kind of still coming into the administration. So I don't know that there's a policy yet, but I think I'm just going to leave it at that.
It's too soon to tell.
It's too soon to tell what the Trump administration will do with this sort of thing. I don't even know what they'll do with Ukraine and Taiwan. I have no idea. Remains to be seen. I know. I observe. I don't know. I observe that the president likes to sort of make grand bargains, and I hope that in doing so he bears in mind our historical interests, the reason why we have the global security architecture that we do, the way it preserves American freedom. That's what it was initially designed to do, to preserve American freedom. There's a great book written by Stephen Wertheim out of the Council on Foreign Relations called Tomorrow the World. And it explains the very brief period of time in which America went from a quarter-spheric defense policy to a global primacy policy. Very short period of time. A lot of people think it had to do with Pearl Harbor. It did not. It had to do with the fall of France and to the Germans, and the probability that the United States would have to confront a consolidated power on one arm of the Eurasian continent that could not just rival but probably dominate global resources and make it hard for the United States to defend itself
But
against.
unlike you, he laments this. Right? You celebrate it. You're like me.
Well, I'm a liberal institutionalist.
Yeah,
It's
so
just
am
in
I.
my blood.
Yeah,
I
I
can't
am
help
too.
it. But I caveat that with, because I know that power governs the international system, and liberal institutions are the only thing that manages that power sufficiently to avoid conflict.
Yeah,
So,
please.
Thank you for the talk. So I wanted to ask another question with regard to Taiwan's status.
Sure.
Is there a formal way for, I know of course it's not practical, but is there a formal way for Taiwan to declare independence, or does Taiwan have to be transferred to one of the powers after one of the major powers in World War II?
I mean, theoretically, one of the possibilities is that Taiwan could declare independence. It has not done so for a variety of reasons, one of which is the threat of Chinese use of force. I mean, it's an explicit threat of use of force for crossing that red line. So one of the future possibilities would be Taiwan independence, but there are others, right? That the Republic of China would govern perhaps all of China, which the Constitution of the Republic of China still claims the right to do, including Mongolia, if memory serves.
Yeah, they get Mongolia.
Yeah, so we imagine the Mongolians might have something to say about that. But
All 25 million.
yeah, so that's one possibility, and then the other possibility, of course, is that the People's Republic of China. Those are the three most logical possible outcomes, and the PRC is doing its level best to ensure that option one, that the PRC becomes the sole government of all of China, including Taiwan and the Pungus in due course.
Thank you. But so they all are legitimate under international law?
Yeah, they are all possible futures that international law does not discount.
But one of the things you had said earlier is this constitutive sovereignty would require recognition from outside powers that Taiwan was an independent state. So they could declare independence and not get sovereign independence in that sense unless others recognize it as independent. And that's always been one of the arguments that U.S. officials have made to the PRC, just like, relax. You're always freaking out that Taiwan's going to move toward independence. First of all, they have a constitution that's hard to change. Second of all, who's going to recognize them? Don't use force. There's no need to use force under any circumstance, including under the circumstance of a declaration of independence, because there are other ways to address it besides the use of force. That might not be popular, but it seems like there are a series of hurdles for Taiwan to get there. And the fact that the U.S. says the status is undetermined doesn't mean the U.S. supports that outcome. And it doesn't mean that the U.S. opposes that outcome. But to get to that outcome would be very, very difficult for Taiwan.
Yeah, so the question of that extra element of recognition, the reason it matters the most, I think, is that once a state is recognized by other members of the UN and becomes a state within the UN, it takes advantage of all of the access to the international institutions through which international law flows, right? It also, and perhaps most importantly, takes advantage of the collective defense rights that are inherent in the Charter. So that it's a big step, but it's also to declare sovereignty and to declare independent sovereignty from the rest of China would also be a big step, I think. And I mean, to a certain degree, I understand the political side of what the PRC is saying, which is that you're then going to incentivize other states to choose between us, right? Or to choose to accept the one China principle, or to allow more states to come back and accept some sort of independent status for Taiwan, even if Taiwan doesn't get into the United Nations, they might expand their international space to the detriment of the PRC. So,
One last question, John.
Yeah, thank you so much, Professor Dutton. Professor Christensen. My question is, if we treat the PRC claim, historical claims, giving them the benefit of the doubt, I was wondering if they, like looking at the new Qing historiography, like at LSC, there was Professor Ronald Poe was examining kind of the maritime consciousness of the Qing dynasty, which kind of really reinforces the idea that there was a maritime consciousness. But even to
Sure.
even to that extent, I think there was, still there wasn't the Grotius kind of model. There was the Tian Sha model where there's kind of like these different layers of.
Let me respond here.
Okay.
So there's a lot of literature on this, and I've read a lot of that literature. And what I conclude is this: that the real big difference between the Ming and the Qing fundamentally was whether the imperial center just thought about the maritime domain as a zone that it needed to control, to exercise control over directly from China. And so I know Fairbank has, kind of maybe didn't get the full extent of how the Qing managed its maritime periphery correct, but I think the distinction there is that whereas in general, the Ming saw the maritime periphery as important to exercise control over, the Qing did not. And it wasn't that they didn't have relations in the maritime domain. They certainly did. The whole system of tribute, continued under the Qing until really quite late into the Qing. But the Qing didn't manage the maritime periphery in the same way. They didn't exclude trade to the maritime partners through the tribute system the way the Ming did. What they did was they taxed it. The Qing used maritime trade as a source of income, actually, for the Qing dynasty. And so it allowed a more open trading system.
As a source of revenue?
Customs revenue. Who knew? So the Qing used maritime trade as a way to expand their coffers, right? As opposed to an expense, which was how the Ming dynasty managed its peripheral system.
Can you take one more question? Because I saw
Yeah, of
someone in
course
the
I
back who
could.
looked disappointed. I hate when a student looks disappointed, so.
Of course I
Yeah.
can, yeah.
I just had a quick
Can
question.
you stand up? I'm sorry, I can't see you. Oh, yeah, there you are.
Just a quick question.
Yep.
If Russia and Japan never formalized a peace treaty after the Second World War, could Russia technically attack Japan? I mean, theoretically, and not be in violation of international law?
I think thankfully there's a United Nations charter which would prevent that. That's clear aggression against a neighbor. That's what I would say is the
So
answer.
my sense, I'm not a lawyer, but my sense is that the Japanese nationalists, right, believe that Russia is doing that every day by occupying the northern territories. In other words, Russia is on Japanese soil, and that's why they haven't had an agreement, is that they can't agree on that piece of territory. At the end of World War II, Russia, having not really fought the Japanese throughout the war, joining the war between the two atomic bombings, seized Japanese territory illegally. And from Japan's perspective, that needs to be settled before you can have a peace treaty.
Yeah.
So that
Stalin did good.
But I always wondered about this. I hate to say it out loud because we're on Zoom, but I've always wondered about this because there were some efforts by Japan and Russia to actually deal with this issue. There were some early noises, right? And then the Russians scrapped it by sending their prime minister to the Northern Territories. But there were some noises about settling. I always wondered if it were settled and they reached a treaty that settled World War II once and for all, what would the State Department's legal position be on Taiwan? Because the legal position is, going back to President Truman, that this is unsettled. And since it's unsettled, Taiwan's status is undetermined. But what if the Japanese and the Russians actually settled that? I don't know.
Yeah, but settled what?
Settled World War II and all the territorial divisions.
I don't think that would be enough because
Okay.
I don't. Because the U.S. has not actually agreed to a transfer of territory over Taiwan, and frankly, neither did Japan. And so if it settles
They transferred it, but to whom? Right?
no, they didn't. They just relinquished control. That's not a transfer. It's actually different. I mean, think about if you own a house, right? You own a house. You can. Detroit's full of it, right? You can walk away from your house. Who owns the house now? Right? Well, the bank. If the bank walks away from it, who owns the house now? Well, now that's nobody really, and the state has to take over it to manage it. But it's essentially, somebody's got to transfer that house to someone else
All right.
before ownership changes.
Yeah, well, that's not
Yeah.
going to happen anyway. Japan and Russia aren't going
Yeah.
to settle this one yet, so.
But I actually don't think even so it would be enough.
All right, interesting. Okay, please join me in thanking our fine speaker, Peter Dutton.
Thanks. I just want to say, like, you know, I really enjoy engaging with students. So if you, if you have questions, or if you're working, if your research relates to it, and you want to chat some more over, just pick up, send me an email. It's easy, peter.dutton@yale.edu. I think it was on the first slide. Yeah, it's just easy. You can find me easily, and I'm happy to chat, or, we can have a phone conversation or something. If you want to pull a thread on something, I'm happy to do it.
And thanks to Amelia. Great job.
Yeah, I really do appreciate it.
Working the boards. Yeah. Nice.
Oh, very
Nice.
nice. Very nice. Okay,
All right.
thanks.